Why don't I just start?
Yeah.
Thank you, everyone, and thank you to the Dialogue Forum for inviting me to participate in this important conference. My name is Sarah Leah Whitson, and I'm the Executive Director of DAWN, an organization that works to reform U.S. policy in the Middle East, and founded by the late Jamal Khashoggi. As I presume you've already discussed today, yesterday on January 13, the State Department and U.S. Treasury Department formally announced the designation of 3 organizations linked to the Muslim Brotherhood, the Lebanese Muslim Brotherhood political party, the Jordanian Muslim Brotherhood, and the Egyptian Muslim Brotherhood as designated terrorist organizations. This follows on the heels of an extensive lobbying campaign by Israel, the United Arab Emirates, the Egyptian government, and even the Jordanian government to seek these designations of Islamist political organizations, which, of course, they feel personally threaten them. What I wanted to do briefly in this talk today is discuss the legal basis of these designations and consequences that may emerge from them. And also drill down a little bit on the 3 specific designations that were made yesterday, the factual basis for those designations. And finally, just talk about some state efforts to also designate the Muslim Brotherhood, but also American civil society organizations. And I think overall, it's very important to understand that as much as these foreign regimes want to see these designations for their own political purposes in their countries, there is also a very strong desire to target American organizations that are deemed to be sympathetic with Muslim civil society groups, Muslim political groups, Islamist orientation. And that is exactly why you've seen the targeting, for example, of the Council on American Islamic Relations, which I hope will be sort of successfully defeated in a court of law, but it is really designed to have a chilling effect on Americans who speak critically of these regimes and Americans who advocate for the political rights and freedoms of Islamist groups in countries abroad. Moving back to the legal basis of these designations and the consequences. The U.S. government has 2 principal authorities to identify groups involved in terrorist activity. For the foreign terrorist organization designation and the specially designated global terrorist designation. And these are 2 different things, even though they sound like they're the same thing. I'll try to explain the difference. But the most important to know is that actually designating an organization as a foreign terrorist organization triggers broad criminal and immigration consequences, while merely designating a group as a specially designated global terrorist organization, specially designated is the words that you're focusing on, only focuses on economic isolation. The government can use both, as it has this week, or it can use them selectively, use them separately, as it also did this week. So first of all, the foreign terrorist organization designation. This is pursuant to an American law, the Immigration and Nationality Act, which governs all immigration into the United States, and has a particular provision, Section 8 of the U.S. Code 1189, that requires the Secretary of State to prove three elements in order to designate an organization as what we call an FTO, foreign terrorist organization. First, the organization has to be a foreign organization. This is the Immigration Act, after all, and this is designed to target terrorist organizations outside the United States. There is no domestic terrorism statute in the United States. Second is the group has to be found to be engaging in terrorism. And there is a codified definition of terrorism, generally understood, however, to mean attacks targeting civilians in order for political reasons. And finally, the State Department has to find that the activity of this foreign group threatens the security of Americans or the national security of the United States. Now, it's important to note that the term national security of the United States is not legally defined and unfortunately is whatever is in the head of the Secretary of State at the time or the President at the time to decide whatever he or she believes is a threat to national security. And I think this is very important, and I'll describe it a little more when we look at the designation of the Lebanese, Egyptian, and Jordanian Muslim Brotherhood. What they based was a threat to American national security. The consequences. So if an organization is determined to be an FTO under this statute, under this law, the most significant thing about it is that it subjects people in the United States to being criminally prosecuted for providing what's called, and it's a very narrowly defined legal term, material support. So it makes it a federal crime, a U.S. crime, to provide support, resources, or services to a foreign terrorist organization. It also bars the members of the group from entering the United States, and it requires financial institutions to block any funds of the foreign terrorist organization that fall under American jurisdiction. But this designation, this combination is what gives the FTO, particularly the material support provisions that allows the US to go after people in the United States with criminal charges for supporting a foreign terrorist organization, its force. Because without this label, the penalties don't apply. The second bucket of authority that the federal government has and is used is something called, as I said, the Specially Designated Global Terrorist Authority, which is really only used to disrupt the financial support network of a terrorist organization. The basis for this designation is from an executive order that was issued after the September 11, 2001 terrorist attacks. And it gives the Department of the Treasury, through the Office of Foreign Asset Control, the authority to identify individuals or entities as specially designated global terrorists and, exert financial pressure on them. So the Treasury can then freeze their assets in the U.S. And globally prohibit nearly all financial dealings with these groups by subjecting them to violations for having financial dealings with a designated group. But this is from the sanctions regime itself, not the material support statute. And it operates primarily as a financial law rather than immigration or membership rules. So the United States has used this foreign terrorist organization designation and material support statute extensively. It has used it to prosecute supporters of Al-Qaeda, Hamas, Hezbollah, the FARC, which is the Revolutionary Armed Forces of Colombia, another armed group in Colombia, the United Self-Defense Forces, Al-Shabaab, and the Islamic State. So the Trump administration has really tried to expand the scope and the kinds of groups that can be targeted using this material support statute, going after government entities, transnational criminal organizations, and even tried to apply it to a domestic organization. And that is particularly novel and particularly dangerous. So in April 2019, the first Trump administration designated the Islamic Revolutionary Guard Corps as a foreign terrorist organization, despite the fact that it is, actually an arm of the Iranian state. And I believe this was the first time that the U.S. government has ever designated a government, a military branch as a terrorist entity. Now, they also have designated the Taliban as a specially designated terrorist group, but that was before the Taliban became the government. Most recently, the government has designated Mexican and Venezuelan drug cartels as terrorist entities. And finally, they have designated the Antifa, anti-fascist group. I don't even know if we can call it a group since it's not clear that it exists as a group, under the executive order. The new designations, the ones that were issued yesterday against the Lebanese, Egyptian, and Jordanian Muslim Brotherhood, were a response to the President Trump's 2025 executive order that gave the State Department and the Treasury Department 45 days to produce a report and consider whether or not to designate these three country Muslim Brotherhood organizations. And so yesterday, the State Department announced, as I mentioned, that it had designated the Lebanese Sunni political party, Al-Jama'a al-Islamiyya, which is aligned with the Muslim Brotherhood, whatever that means, as a foreign terrorist organization under the Immigration and Nationality Act. The party has a seat in Lebanon's parliament right now, so I'm not sure what's going to happen to this member of parliament. The State Department also designated them under the executive order as a specially designated terrorist organization. I think, and if we have more time in the discussion, I'll go through that the department claimed that the armed wing of the Lebanese group, the Al-Fajr forces, had carried out attacks on Israel during the Gaza war, but offered no evidence that these attacks were terrorist in nature or that these operations threaten U.S. security interests. The allegations against the Egyptian Muslim Brotherhood and the Jordanian Muslim Brotherhood are even vaguer or looser. They generically claim that they have supported Hamas without specifying how. They generically claim that people associated with the Jordanian Muslim Brotherhood have built weapons, again, in and of itself, not evidence of terrorism, but nevertheless have used this as the basis for designating these organizations. Not enough time left to tell you about the state efforts to target Muslim Brotherhood-linked organizations and civil society groups, but I think overall important to understand that there is a very deliberate political context in which these designations are taking place.